SJC-13430, Commonwealth v. Denzel, McFarlane.
Okay, Attorney Cohen.
Good morning, Your Honors. Attorney Cohen on behalf of Appellant Denzel McFarlane. This case is about the Commonwealth's obligation to turn over exculpatory Brady evidence related to a pending civil lawsuit for police misconduct, particularly in this case, false arrest. Defendant McFarlane's defense at trial essentially was false arrest. He had testified that he had recently purchased, just minutes before, purchased a used vehicle, was driving down the road, had a problem with the vehicle, pulled over, but he had done a brief inspection of the vehicle. He checked the engine, he checked the mileage, the windows, a brief inspection, and he had seen no gun. He testified that he had no gun, there was no gun.
What are the bounds to the discovery obligation on civil actions or civil complaints?
Sure. Well, in regards to exculpatory evidence, I would suggest any evidence having to do with police misconduct, almost by definition, is exculpatory.
So if a police officer pulls me over and is rude to me, and I go to the chief and I say that person was a jerk when he pulled me over for speed, and do something about him, that's misconduct, right? Is that discoverable?
Your Honor, I would suggest...
Trying to get you to say, because we have...
Yes.
You know, we have the in-rate grand jury case, right? Dealing with credibility and the like. We don't have 608B yet. Maybe we will, I don't know. But what are the bounds of this rule you want us to get into?
I would suggest police misconduct rising to a level, certainly, that involves a civil litigation for false arrest. That would rise to a level that would be discoverable.
Why? And I'm not being glib. Sure. You can allege anything. So if somebody files a civil lawsuit and they allege all manner of things, whether it's proved or not proved, it would fall in your category of this is what you've got to turn over. So sure. back to Justice Gaziano's point, it would seem to encompass then, if there's a complaint because you were rude to me, it hasn't been proven, just like a civil complaint that's just been filed, that's not been tested by anything, it's just a conclusory complaint.
Sure. I would suggest and admit that perhaps the value of the civil lawsuit itself, the mere civil lawsuit, has a minimal level of exculpatory value, but what's important about the civil lawsuit is the underlying specific allegations within the lawsuit. Again, in McFarlane's case, there was a specific allegation of false arrest. This was the thrust of his defense, false arrest. I'm sorry, I gotta gather my thoughts for a moment.
That's okay. Yeah. Counsel, I don't mean to short circuit your argument, but you know, you're putting a lot about the fact that McFarlane's complaint focuses on this officer, but it really leads into the last part of the analysis for the prejudice, because you're putting a lot in saying, let's assume for the sake of argument, you get rid of this officer. It was in his testimony duplicative of actually really the main actor, the main police officer who had all the interactions, had all the statements from him, found the gun. I mean, so if we assume for the sake of argument that this is all exculpatory and it should have been turned over, don't you have a real tough road to hoe on the prejudice aspect?
Certainly there was another officer on the scene, Officer Phillips. Officer Phillips was the one that initially claims to have seen the gun in plain view. However, in McFarlane's trial, you know, essentially it's a credibility contest. On the defense side, you had two witnesses, Mr. McFarlane and his passenger, Chandy Jones, who both testified there was no gun, we saw no gun, there was no gun. The implication is that if there was a gun, perhaps it had been pushed further between the seat. Again, he had just purchased a vehicle. Perhaps it had been repositioned by the police, i.e. a false arrest. On the Commonwealth side, you had two officers reinforcing each other. I would suggest that if you were to credit McFarlane's testimony, that there was a false arrest, that this gun was repositioned, that in fact, impugns perhaps both officers. Certainly, it casts some doubt over the credibility.
Was the civil lawsuit a collusion, cover-up kind of lawsuit, where Moynihan was accused of covering up or colluding with a fellow Springfield Police Department officer? Because it seems to me that if that were the case, and I don't know, sitting here today, that might lend some credibility to your impeachment of Phillips through the impeachment of Moynihan.
I guess I would say yes, Your Honor, because as I consider that case, again, there was that involved false arrest. The officers acted in concert. The two officers, in fact, were found liable.
You don't know. Okay, my question was a factual one. Do you know if that civil lawsuit was a collusive kind of
the way I view it, I would suggest it is. There were two officers that were found liable. They were acting together in concert. Moynihan, in that case, again, was found liable for false arrest. Just Moynihan's testimony alone in the Bradley lawsuit, he sort of implicated himself. And this criminal trial transcript, by the way, would have been available to defense counsel McFarlane's case. There was no adjudication of the civil lawsuit yet. But had he been informed of the civil lawsuit, that would allow defense counsel to get to Bradley's criminal trial transcript. Within the criminal trial transcript, Moynihan says that defendant Bradley, that he was moving in a suspicious manner. He pulled him out of the vehicle. On cross-examination, Moynihan admits, despite this suspicious movement, he didn't illuminate the area with his flashlight. He didn't ask the defendant or Bradley if he had a weapon. He just immediately pulled him out, and it continued from there. But again, he was found liable for false arrest, among other things.
So doesn't that sound like a trial within a trial?
Right.
I mean, it really does get very complicated, to agree with your position that this would have come in.
Yeah, I mean, it's a rather brief colloquy.
Especially where we have a civil lawsuit, not a grand jury indictment like we had in regular grand jury, right?
Right.
Isn't that?
But it's in black and white in the transcript. It's a relatively brief exchange. Moynihan's own words on direct and then cross. It appears that it may have been a false arrest, whereas McFarlane is asserting essentially it was a false arrest. There was no gun. If there was one, it was repositioned. It's a credibility contest. You have two witnesses on the defense, two witnesses on the Commonwealth side. The jury has to weigh who to believe. McFarlane was asserting false arrest, and if this cross-examination of Moynihan were to raise this doubt of false arrest, certainly I suggest that's prejudice. The jury very well could have, would have considered this evidence differently, and may have come to a different, very well, may have come to a not guilty finding.
Counsel, but if you take that math, and you're saying you have to go all of these different layers, dovetailing off of Justice Wendland's question, this is an abusive discretion standard, right? For the trial judge to say, you can't go into this, right? I'm not going to let you go into this. So given all of these back and forth, and it has to be this, it might be that, how can this be an abuse of discretion? Because it's got to be clear, right? I mean, if we know what the definition of what an abuse of discretion standard is, that no trial judge would come down and say, no, I'm not going to let you go through all of this kind of Rube Goldberg kind of ways that we go back to how this may be relevant, because I have to get into the testimony of the underlying criminal case where we see whether or not this is collusive and whether or not this is a false arrest. I mean,
sure.
Can you illuminate that for me?
The appeals court indicated in its decision that it wouldn't have necessarily agreed with Judge Murphy's decision to deny our motion for new trial on that basis. The motion judge said something about this evidence concerning Moynihan being too old, yet at the same time, it wasn't right because it wasn't adjudicated. Of course, the judge ultimately has discretion whether to admit this evidence. But you know, particularly with McFarlane, I think the real key is the thrust of his defense was essentially a false arrest. One of the two testifying, arresting officers, so Moynihan was very much involved, almost as much as Officer Phillips was, I would suggest. And yet, it appears he was involved with a false arrest. This is very much on point of the heart of McFarlane's defense. So I would suggest, yes, that's an abuse of discretion. He was denied the ability to put on the case, the strongest case, relating to the heart of his defense.
Anything else?
Just to, if perhaps I should mention Guardado briefly. I know the Commonwealth brought up another case, Bookman, and there was the issue of prejudice in Guardado. The Commonwealth argues that there was no prejudice in this case because McFarlane admitted that he had no license to carry. I would suggest that if McFarlane were granted a new trial, counsel possibly could file a motion to suppress that statement that he had no license to carry. Perhaps the argument would be that Officer Phillips.
Well, this just goes to whether it gets a new trial versus whether it's vacated, right? The Guardado issue.
Right. The argument would be that Officer Phillips demanded that he turn over his license to carry, and it puts McFarlane in a position where, you know, essentially, arguably, that statement was involuntary. He was responding to a demand. So I suggest there is some prejudice that would go to Guardado.
Okay.
And actually, if I can add one more thing. I know the Commonwealth talks about the post-commission website. The post-commission website elucidates disciplinary actions within the police department itself. I took a look at it in regards to Officer Moynihan particularly. There are a couple cryptic mentions having to do with improper processing of a prisoner, discipline other, conduct unbecoming, written reprimand. But despite the supposed publicity relating to the McFarlane civil lawsuit, there's no mention of that whatsoever. The post-commission website does not get to issues such as what's relevant here, which is a pending civil lawsuit. I don't think the post-commission website certainly doesn't fully address defense counsel's need for exculpatory evidence in this way. I know the Hampton County District Attorney's Office, for example, currently has certain questions.
Doesn't that suggest there needs to be limitations on this too? Because are we going to have a trial within a trial on all 9 of those that's in the commission's disciplinary? Are we going to have each one of those revisited?
No, my point is simply the post-commission website is insufficient. It doesn't expose this type of misconduct. And you know, a simple question. Obviously, prior to trial, a prosecutor needs to converse with testifying police witnesses. I'd suggest it's not too much of a stretch for that prosecutor to ask a question. Do you have any pending civil allegations of police misconduct? I know the Hampton County District Attorney's Office is currently utilizing a brief questionnaire of that effect. And those questions are appropriate. And again, that we argue that should certainly exculpatory should be turned over to defense counsel.
Okay.
If there's nothing further, I'll rest on the briefs.
Thank you.
Thank you.
Attorney Jacobstein.
Good morning, Your Honor. Rebecca Jacobstein for Amici, CPCS, and the ACLU of Massachusetts. Thank you for granting us oral argument time today. I would like to address 2 issues. First, the parameter of a prosecutor's automatic duty of inquiry, and the suggestion by other Amici that the post-commission database is sufficient to fulfill that obligation. But first, an area on which we have agreement, I think, which is that I agree with the district attorneys and the state police that this court should provide guidance about the scope of the Commonwealth's duty of inquiry. It appears the DAs are concerned about their working relationships with the police, and clear and explicit requirements from this court will enable the DAs to obtain the materials to which defendants are constitutionally entitled while not taking the blame for asking for them. So the law regarding the prosecutorial obligations is clear. Prosecutors must obtain and disclose exculpatory evidence. They must err on the side of disclosure. If the police have it, the prosecutor has it. But exculpatory evidence need not be admissible. It just needs to lead to admissible evidence. And just because we have it doesn't mean we always get to put it in. So just to address the questions that the court was asking counsel, if things are going to lead to a trial within a trial, if they're not relevant, they don't come in. But that doesn't mean they shouldn't automatically be disclosed. And I think a reasonable inquiry is one that gets information about the case, but also gets information, like relevant impeachment information about all of the officers involved.
All right, so we got to get down to brass tacks as far as the civil cases and the like, because we have, in my mind, we have in re grand jury, which stands for a proposition of, but that was an indictment and it had to do with credibility, right? So that's our guidance from this court thus far. And we don't have 608B, right? So where do we draw any line for this guidance that we all want to give to everybody as far as civilian complaints, civil lawsuits, et cetera?
So I think, Your Honor, that the inquiry is expansive, and I also think the disclosure is expansive. Maybe the admission is not, but the disclosure is. And so, for instance, I have a list. Criminal charges against an officer, civil cases relating to the officer's professional duties, not all civil cases, just those, that are either pending or have settled or there's a guilty.
This your own list, or are you getting this from like a federal Giglio case, or how?
This comes from my own personal wish list, but also from the Giglio, and just experiences, and also Milky, the Ninth Circuit case.
'Cause that's what I'm going to ask you for, because when we're writing the decision, trying to get guidance, a good source would be to see where the federal courts have gone on Giglio obligations, right, on civil cases.
Right. I don't know if Milky has civil. We quote a case from New York about civil cases in our brief, but I don't know if Milky actually addresses civil. I know it addresses judicial determinations, both of truthfulness and constitutional violations.
All right, so you've told me about the source, because I want to, obviously, we need to check that, but not, obviously, I trust what you write and tell us, but give us your wish list again.
So,
and this time I won't interrupt.
That's okay. Internal affairs investigations that are sustained, pending, or relate to the case at hand. Milky actually did rule that it is contrary to clearly established federal law when prosecutors fail to disclose findings in an internal affairs report. Judicial findings that an officer was not truthful, that the testimony was inconsistent with another officer's testimony, or with the physical evidence. Orders on motions to suppress or dismiss where the officer is found to have violated defendant's constitutional rights. Again, I think both of those are in Milky. And evidence of bias, which I just took out from the fact that bias evidence is always admissible. So
The internal affairs investigations, is that, do you include anything that's been opened or things that have been finalized?
I would argue that it's those that are pending and those where there has been a sustained finding.
Okay, so I get pulled over for speeding.
I'm sorry?
I get pulled over for speeding.
Yes.
I think the officer's rude. I file a complaint.
Yes,
Discoverable?
absolutely, as well while it's still pending. And even if it's sustained, does that come into evidence? Is that even of any use to me?
Well,
I don't
mean,
know,
we
it
have to be
depends.
careful because, I mean, we obviously came down hard on prosecutors last month or this month. So as far as discovery obligations go. So they have to basically ask every police officer, do you have any irate motorists that are mad because you pulled them over?
No, I think the question is do you have any open, pending, or sustained internal affairs investigations against you that you know about?
Open. So again, anyone angry can file, complaints, right?
Yes.
It's open. It could be complete nonsense.
Could
It could
be.
be filed by a mentally ill person, right? I mean,
And I guess your point is that it's just discoverable, not that it's admissible.
That's exactly right, Your
And so
Honor.
maybe whether it's admissible would go to the strength of the allegation, the stage, but you're just asking for it to be disclosed to defense counsel, right?
Right, that's exactly right. We just
get
want the
that.
judge to be able to decide whether it's admissible, or us to even decide before that if we want it to be admissible, before, instead of the prosecutor or the police determining whether even we get to know it.
I get the first part is much more generous, and we've expressly stated that. But, so get to the second part, because you're running out of time, because that seems
out
to
of
be
time.
where the rubber hits the road. We've got all kinds of civil cases. This court gets sued nonstop. Civil cases, they always get thrown out because they're often nonsensical. Similar things can be filed against police officers. I mean, don't we have to be careful about where we're going here? Because otherwise, we're not going to be able to have a police officer testify without a trial on 25 prior incidents. So where are we going here?
I don't think, Your Honor, that most officers have 25
really?
prior incidents.
You don't think there are there are little grievances filed in all the time, and there are civil complaints, many of which are dismissed out of hand, class action suits that we got to wrestle with? I mean, we need line drawing here, or we're not going to be able to proceed in the simplest
Can I
cases.
ask you, I'm sorry, Jessica.
Yeah, can she
Does
answer
the-
that? Where
does
do
the
you
G-
draw,
does the-
can we ask, where do we draw lines in civil cases on the hard part?
When you're sitting as should it come into evidence, or whether it should even be disclosed?
Well, I get the disclosure issue, and we've talked about that. I'm much more worried about the second part of this. And are we going to encourage kinds of nonsensical complaints against officers as well? Because then, so all of a sudden, that becomes part of every criminal prosecution too. So where are the line? Tell us your wish list of where the line is now on the second part of this.
On the, should it be admissible?
Yeah.
I think that the line there is already drawn, which is if it's not relevant, if it's not material, if it's.
Well, but you say, at least in discovery, could it lead to something relevant? So does it have to be, and what is relevant? I mean, a false arrest can be 18 different things. False arrest can be there actually wasn't enough for reasonable suspicion, or a false arrest can be they made up
Yes,
the claim.
yes.
A made-up one is totally different from a bad judgment call on reasonable suspicion, isn't it?
I agree, and I think that judges will understand that. I think that for our purposes, what we really need is to have it. If we don't have it, we can't have these discussions about should it come in, should it not come in, is it a trial within a trial, or do I just say, and you were found to have violated?
I think the easier
Don't
part
you
is
always
first
win
one.
though? On that, basically, just give it to us, then we'll figure it out later. So every time you have a wish list, we say, and you say, we're not saying it's admissible, but you have to come and find it. And then we have these discovery obligations we're imposing on the Commonwealth. We say, well, just give it to them. What's the harm? That's the answer?
I agree. And I mean, I think that they are able to do it. We have these that I believe with the state police's amicus brief, there was a provision of some worksheets that they send to, or questionnaires that the district attorney's offices are using. So it's doable. And
It's been a long time, but I remember in federal court, we had questionnaires we would send local law enforcement authorities under giggly obligations, correct?
I believe that there are a lot going on in federal court that didn't necessarily go along here.
Can I ask you one last question? The DOJ guidance on this, do they ask about pending civil lawsuits?
I think they don't, but I'm going to double check and be sure.
Because we can't, as we said in grand jury, tell the DAs to do a giglio list, but we can tell them what their obligations are, then they have to comply with it.
That's exactly right. Thank you, Your Honor.
Thank you. Okay, Attorney Shepard-Pritt.
Thank you, may it please the court.
What's wrong with asking?
And I think the problem is that we've conflated asking with disclosure, because the list in re grand jury, that part of the policy of all of those things are things that the agency must turn over to the prosecutor. That's not a list of what gets turned over to defense counsel. That information in the Giglio policy goes to the prosecutor. The prosecutor then looks at it and says, is this material? Is it relevant?
Well, that's kind of dangerous, isn't it?
Right.
Well, that's what, I mean, that's what the federal policy is. And the federal,
You want,
That
you really-
consistent with the federal law that requires the disclosure of even possibly exculpatory information?
I mean, it is because
you want that obligation?
the obligation to,
To ferret out what you think they deserve?
Right. And isn't that always going to be looked through the gleam of a prosecutor's eye?
well, it is our obligation whether we want it to be or not. And we certainly have, I mean, our policy is certainly to disclose if we're uncertain. I mean, that's our policy. What is constitutionally required and what our policy are two very different things. Because constitutionally, and for Article 30 purposes, what this court can require is it material? Is it exculpatory in the Brady sense? If it's not, we can still turn it over in our discretion, and we do most of the time. I will tell you that a lot of the times when we've made these disclosures, we've actually gotten motions after the fact saying, tell us why this is exculpatory. And our answer is, it's not. We just turned it over because really the wish list is let them have it so they can decide. No, the wish list is let us fail to turn something over so that then they can come back and say, oh, you didn't turn it over.
Why is it, going back to Justice Scaziano's question, so onerous on the prosecutor to ask their police witnesses, is there a pending civil lawsuit against you?
So let me take you down to the Springfield District Court where a prosecutor is on trial. He or she has a case list of maybe 12 cases that are on trial that day. Each of those cases probably has 7 police officers or 8 police officers listed on the police report. They're probably not going to actually meet with more than 2 of them, probably only put on 1 or 2 for trial. We have to pull 20, 30 police officers off the street and have this conversation with them. It's not practical.
Well, that's not really an accurate lens, because you're saying that obligation springs at the time of trial. From the time of the arraignment, the district attorney's office is going to have the 1-1 and see all of the officers that are involved in this collar, and all of that stuff could be asked long before we get to the day of trial. So I don't follow that.
I mean, it can't, I mean, that's the thing is, the only time that we're able to meet with these police officers is right before trial. That same person who has 12 cases on for that week or that day has a caseload of 300-400 cases.
Well, that just suggests maybe there should be a policy about tracking how you disclose that. It doesn't mean that it would be onerous for you to ask. It's just a matter of how you keep track of the information.
Well, we do keep track of the information, and we have, when we discover information that we think might be potentially exculpatory, or frankly, even when it's not potentially exculpatory, but we don't want to be accused of not turning it over. We have.
So if you stumble upon any relevantly exculpatory information, then you have what?
We do have a database where we keep all of this exculpatory information.
Why can't you just ask? I get it that on the eve of trial, maybe it's hard to pull, as you say, officers off the street, but there must be another way.
Well, so there is another way, and it doesn't work under our state system.
Can you explain that? That would be helpful.
So under the Giglio policy, the agency reports to the DOJ. The DOJ is run by the Attorney General. Everybody reports to the Attorney General. If I go to a police officer or to a police department and say, and this court said in Juanes, if I go to the police and say, give me your IA files, they can tell me no, and there's nothing I can do about that. And so the district attorney's office doesn't have the authority over any of the police departments to require them to turn over any of this information.
You have the authority over the prosecution,
Correct. So anyone in our office,
and you have the authority as to who to call as witnesses.
correct.
That's the hammer, right?
Well, right, but so essentially, we're gonna have to say, well, if you don't turn it over, we're not gonna prosecute your cases. That's not in the public interest. We can't have a policy like that because these cases are, some of them are serious felony cases. We can't hold that. We would be derelict in our responsibility
Or if
to
you
the
don't
public.
discover, or if you don't answer discovery, we're not going to call you, Officer Smith, as a witness.
Right, but again, we would be giving up our responsibility to protect the public in doing that.
And so you think the price for that responsibility is that the defendant is not entitled to Brady information?
Well, the
And
defendant
you
isn't.
don't ask for it.
Well-
Unless you stumble upon it, as you said earlier.
Well-
You don't ask for it because it would be too onerous.
Well, so
More important things to do.
well,
That's not really true, right?
No.
You do ask for certain things and you don't ask for other things.
we ask for Brady
I mean,
information.
from what I understand, I haven't read the case we're hearing on Wednesday involving the Springfield, but my understanding is there's a policy in place to produce certain types of things, and the question is, what does it cover? So you do have a policy, right?
That's correct. We have a policy, and we have been asking officers these questions, and it turns up with no Brady information. We might we sometimes turn it over anyway, but
But
we
you
have.
don't say to them, give me Brady.
No.
You do a modified wish list,
Well,
right? Or a
well,
modified
we've been
questionnaire.
ordered, based on footnote 16, to ask those questions. Now, we get a lot of responses from police officers, which is, what does that even mean? And our answer is, we don't know,
I'm sorry, I didn't hear, footnote 16?
from the appeals court decision in this case. But there have been judges issuing orders saying, ask your police officers these questions. And we do, and they go, what does that even mean? And we say, we don't know, that's just
Which word don't you understand in footnote 16?
Can I jump in at some point? You go ahead and answer that, but I would like to ask the question afterwards.
Okay.
So which word in footnote 16 do you not understand?
So what an informal external charge of misconduct is. I think that goes back to the Justice Gaziano's example of, he gets pulled over, he goes in and complains the cop was mean to me. Is that that might be an internal informal charge of misconduct. Is somebody driving by a police officer saying, oh, that guy's a jerk, is that an informal external charge of misconduct? I just don't know what that is. So I can't tell my police officers what they need to tell me if I can't tell them what that is. Now, I know what an IA investigation is, and they know what an IA investigation is. A lot of times they don't know it's going on. So asking them doesn't get you the answer.
When you say a lot of times they don't know what's going on, what do you mean?
Pending IA investigations, the police officer is not necessarily made aware of a pending IA investigation. They will be made aware once there's a finding or at a certain stage in the investigation, but in the initial stages, they might not actually be aware of it. So, and as this court said in Juanes, we don't have IA. We don't have those files. The cities have those files, and they won't give them to us. I mean, we try to get them, and they often won't. They often say no, we can't have them, and there's nothing we can do about that.
Justice Cipher?
Are you ready for my question now?
Yes, thank you.
Thank you. I'm curious about a couple things, counsel. One is, what was your reasoning in writing in the brief that you agreed that you were in control and custody of this particular information?
I'm sorry, I
Yeah,
couldn't understand.
I think it was.
You can't hear me?
Yeah, what's the belief that you were under control, custody of this information, correct, Justice Cipher?
Right. Why did they believe that? How can they articulate the reason they said that?
So I'm sorry.
Why did you say, or not say, you were in control or custody of this information in this case?
So, I mean, because the officer was part of the prosecution team, in theory, we would have control of this information. Certainly, there are courts that have said that we don't have this information.
Wait, an officer on the prosecution team knows that there's a pending civil lawsuit, and you say there's courts that say that that's not within the prosecution team's control?
That's correct. There's a federal case cited within my brief.
Is that the law in Massachusetts?
The law in Massachusetts is not settled on this point as to, what we certainly know what the police officer knows with regards to the case, but asking, and it's the case where they say it's one thing to ask your police officers for potentially exculpatory information in the underlying case. It's another thing to ask us to conduct complete disciplinary inquiries on every person who has touched this case.
But that seems a far cry from asking the officer if there's a pending civil lawsuit against him or her.
Well, but
We're not asking, hey, can you see if Moynihan ever committed something? It's just, Officer Moynihan, do you know if there's a civil lawsuit against you?
Well, but again, there are a lot of frivolous lawsuits.
I mean, you didn't pay your credit card bill, or you didn't pay your phone bill and Verizon's brought you into small claims court. That's a civil lawsuit. I take it we don't have to.
Oh, no, related to your conduct as an officer. I'm sorry. Yeah, that's a good point, Justice Gafker.
Okay.
Well, but arguably, Justice Wentworth, couldn't that be argued that it's related to the conduct of an officer and that it goes to responsibility in following regulations?
I'm sorry, I'm having really trouble.
That's okay. You can skip that question. That was a different point.
Okay.
Let me ask you another question. Is there what about your civilian witnesses? Could this be and should this be extended to your
Justice
civilian
Cipher, maybe if you pull away from the microphone a little bit.
All right. Would this apply to your civilian witnesses?
What about as to our civilian witnesses? I mean,
Wouldn't the argument the next step of this be that you should investigate or ask all your civilian witnesses the same questions?
I mean that it is, although they're even less under our control and they're not part of the prosecution team. And I think that is sort of the slippery slope argument that, that we'll be having to have these same conversations with our witnesses, which, and I would, I'd like to go back to
But you pointed out, they're not part of your team.
Well, right.
Okay.
But
So it seems like there could be a limiting principle, right? Credibility calls about people on your team related to their conduct as officers.
right. But I think the limiting principle is more than that, because police officer misconduct is a huge category. What we're talking about here is, in the very limited exception of police officer misconduct that relates to their credibility and only to their credibility. And I would point out,
Grand jury is a little more open-ended than that, right? I mean, it starts out by talking about credibility and then it moves into misconduct. It's hard to know whether it's misconduct directly related to credibility or broader, right?
well, right. So I think that it's a little ambiguous, but what I would go back to is our rule of evidence, which is Giglio is based on the federal rule, 608B, which says specific instances of misconduct relating to the officer's truthfulness are admissible on cross-examination, and there's no trial within a trial, because if they deny it, extrinsic evidence doesn't come in, it's done. But that's on that very limited issue of character for truthfulness. Now, this
I have
court...
one more question, if we have a moment, and that is, what is the point at this point of having a distinction between a specific request and a general request for discovery? Is that irrelevant at this point?
I'm sorry, I'm having trouble
The
hearing.
distinction between a general request for discovery and a specific request on the standard of review,
Well-
is that even a thing anymore, basically?
Well, I
Given
mean,
this widespread disclosure?
well, right, and I mean, I think that the reason that you have the specific request versus general request is I don't know what the defense strategy is. I can try and guess, but if you tell me, like, my case is about lying police officers, I want to know if your cops have ever been found responsible for lying. Okay, that I can ask about. But if it's just a general fishing expedition, I mean, I don't know what rock I'm supposed to look under, but I do know what's admissible and what's not admissible. And none of this, I mean, we have the Bohannon exception, which I suggest that it may be time for a retirement, given that it was based on the idea that we don't trust rape victims. So it's a little questionable whether that should even still stand. But you have this, okay, so now we don't also trust police officers. That's their second category under Bohannon. It's rape victims and police officers. But we don't have this rule of evidence. We don't allow prior instances of misconduct that relate to an individual's truthfulness. You're not allowed to ask about that unless there's a conviction. If there's a conviction, it comes in. But absent a criminal conviction, it's not admissible under our rules of evidence. It's not likely to lead to admissible evidence. If we have a police officer who's...
There's a difference, between disclosing something that might lead to admissible evidence and the admissibility of that evidence.
There is...
That we should collapse the two because we don't yet have a 608B?
I'm saying...
And that Bohannon should be retired because rape victims are similar to police officers?
Well, what I'm saying is that we should... one of the... I like the language from People versus Garrett, which the Amici relied on for a different proposition, but and then People versus Smith, which stands for the unremarkable proposition that law enforcement witnesses should be treated in the same manner and as the same as any other prosecution witness for the purposes of cross-examination. And so my point is, we don't allow anybody else other than rape victims to be cross-examined on these sort of prior false allegations.
There's a small window in the in re grand jury case, though, right?
Right.
It says in a judge's discretion, this bad act evidence can't come in, right?
It can come in, right. So if it is
We don't have 608B, but there's a sliver of it in the in re grand jury case.
Right. So if it relates to the officer's character for truthfulness, if it is an allegation that they have filed a false police report that is sustained, if there is a claim that they have committed perjury, obviously that's exculpatory. But that an officer, and in this case, if you read the federal trial, in the federal criminal trial, civil trial rather, basically the jury was instructed that furtive movements are insufficient for a pat frisk or an exit order under Massachusetts law. They were not told that unless it's consistent with retrieving an object. So the jury here basically found that he issued an exit order without reasonable suspicion and arrested him without probable cause. Based on the instructions, it was a very close case. This court decides cases like that all the time where, like, well, the officer thought they were doing the right thing, turns out they didn't have it. That doesn't relate to their character for truthfulness.
But that's still your view of it, because that doesn't take into account the other side of what was argued beforehand. Because if you don't disclose this case, they can't look at the underlying case, the underlying criminal case that gave rise to it. And if you then marry the potentially lead to admissible evidence, that is the part where they get to go and look at the transcript of the underlying criminal case and, in fact, get evidence that might be relevant to the character for truthfulness. And they can't get there if you don't disclose that they have this open civil case. You just can't get there. They can't know what they don't know.
Right. Well, and we can't know what we don't know, and
you can know if you ask.
I mean, one, we can ask, but we don't always get.
Sure. I mean, people can always not tell you the truth, but what we're talking about is whether or not you should have an obligation to ask and what might lead therefrom.
Well, but if we have an obligation to ask and we don't get, then we're on the hook for it when this is never coming in. This stuff is, I mean, this was never coming in, the judge was never going to let it in, and...
But then you got the prejudice argument.
Well, right.
The question is, you must, whether or not you should ask. That's the question before us.
Well, I think that's difficult because the question...
Because you're suggesting that your officers will lie when you ask them, which I don't know if that's really what you're...
No, my argument is sometimes they don't know, and sometimes they don't, sometimes they don't remember because it's been 20 years. And then is that, what are we doing at that point? I mean, a criminal conviction that's over 10 years old, even if it's a felony, doesn't
Okay, I'm
come
gonna
in.
say we've fleshed this out pretty well. Thank you.
All right, thank you.
And I'm gonna ask Attorney Hanley to come on up.
Good morning, Chief Justice Budd, members of the court. Thank you on behalf of the State Police Association of Massachusetts and the president who's here today for allowing me to present today. I'm with my colleague, Beth Keeley. I'd like to, rather than go to what I prepared to say, I'd like to try to jump into some of the questions that I've heard already. So in terms of creating a bright line rule, I'd suggest that a proven allegation of misconduct, wherever it was proven, whether it's to the post-commission, in a civil lawsuit, in a criminal lawsuit, or in internal affairs, that's reasonable to look for. Where the police officer was a party, so that distinguishes it from a motion to suppress that maybe a judge concluded that there wasn't probable cause to, issue to search a car or something like that, because the police officer is not a party and isn't preparing the case. So I think that's distinguishable.
So say if the police officer is a party to a civil litigation?
Yes, if they're a party to the civil litigation, I'd suggest that if I'm going to get to what the reasonable inquiry should be, but I'd suggest that it should be turned over if it is found. Again, so in other words, where they're a party, where it's adversarial.
What if in the motion to suppress the motion judge finds not just that the police officer was not credible, but that the police officer lied? Would that be something that should be turned over?
I'd suggest no, not automatically, but I'm going to get to that in my list, if you don't mind, because I...
Oh, go ahead.
Okay. That scenario in my list. I'd suggest that any pending criminal charges are already discoverable. So under Rule 14, the DA's office is supposed to give all the names of the police witnesses to probation. Probation is supposed to give criminal records to the defense. There's no caveat or carve-out for police officers. And in fact, the reporter's notes for Rule 14 say if a police officer, as rare as it may be, I think is what the reporter's notes say, if that police officer has a criminal record, that is discoverable too. So that addresses pending criminal charges. And then to the, Justice Winlet, I think the response I'm about to give you dovetails with your question about the DOJ, what do they have to turn over? So the DOJ manual says that if a judge or the prosecutor's office concludes that, for example, just to make it easy, that a police officer has been untruthful, then that is disclosable and is distinguishable from, I think, a pending lawsuit or complaint against that officer. So
A finding of untruthfulness.
Finding of untruthfulness. And I think that's consistent with this court's in-reg grand jury investigation, and that provides a way to draw a line, that if there's a grand jury investigation and there's a finding, in that case, I guess, of untruthfulness, that there you have reached a threshold to turn over information that is exculpatory, but maybe has not been adjudicated, and a DA's office, with that responsibility, is in a position and has the obligation to turn it over. I think
That would include a finding by a judge and a motion to suppress, right?
It would. The problem is I'd suggest that it's not always totally clear whether or not the decision on the motion to suppress is...
Well, if
Right.
a judge just says, I find that they didn't see things in plain view, or, and they couch it and they sometimes are overly polite or whatever reason, if they're ambiguous, but if a judge says, I find that Officer Smith wasn't credible,
then a
That's a
DA,
That's a finding of untruthfulness.
that's a finding of untruthfulness, and it's really not where
Versus
myself.
Officer Smith saying, I saw it in plain view, and the judge said, no, they didn't see it in plain view.
Right, and I think that's not the battle for the police association. If the DA's office has it, if I'm in the DA's office, I turn that over, right? Because that's on the line. Prosecutors should err on disclosing, and I think in that instance where that's known to the prosecutor's office,
Does that
why wouldn't they disclose it?
Does that complete your list of, you gave us 3 things. Does that complete your list?
I think it completes my list, and then I get to, okay, what should they be asking for in terms of what is reasonable inquiry?
Okay, but before you do that, and similar to what I asked Ms. Jacobstein on her list, her wish list, which is a little different than yours.
I had the heads up, so I
Right,
thank you.
right. Is yours based upon certain federal giglio cases?
No, I'd suggest it's based on what is I think a common sense construction of what is likely to provide significant aid to the defense, which is built into the definition of exculpatory. It seems like that's a fair place to put it, and also you got to put the line somewhere. It seems, but and I think is a fair place to put it. It includes almost everything that I think the Innocence Project and CPCS is interested in, but it weeds out a complaint to the police chief that has not been proven, but it does not include.
Can I ask one complication? We have a pending civil case. Now, I'm not saying, say the facts are completely different. There's a 1983 case that says this officer, makes racist stops all the time, and this is pending but not decided. And I'm worried about the situation which we're in this case, which is the verdict comes down afterwards, and then we've sort of got a mess on our hands. Are there exceptions to your rule about pending civil cases, or is it all civil cases?
I'd suggest that's a no, but it doesn't leave defense attorneys with no recourse. They all have access to Google. They all have access to Pacer. We all have access to mass courts. Is it cumbersome? But this search can happen in 15 minutes. And
But which way does that cut? I mean, I guess I read that in the briefs, and it seemed to me, well, then the prosecutor should do it.
Sure, but maybe the prosecutor could do it. But ultimately, I just suggest it's then what? What comes? You have an unproven allegation of misconduct. It's unproven at that point. It ends up being proven, but at that point it's unproven. It provides no significant aid, and so that's why I'm suggesting to this court that that's where the line should be drawn. And I'd suggest, again, I think I talked a lot about the post-commission in my brief, and it was because it seemed like a big deal that all the police misconduct in the Commonwealth was being published on a website. And it's been updated. It's been updated since it was initially published. And it really, the appeals court suggested that prosecutors have greater access. I think when the appeals court wrote that decision, that was true. I think now access may be tips to the prosecutors because there might be some information they don't know. But overwhelmingly, the post-commission provides such great access that it really solves this problem.